Chers collègues,
Colleagues, I call this meeting to order. Welcome to meeting number 86 of the House of Commons Standing Committee on Industry and Technology. Today's meeting is taking place in a hybrid format pursuant to the standing orders. Pursuant to the order of reference of Monday, April 24, 2023, the committee is commencing consideration of Bill C-27, an act to enact the Consumer Privacy Protection Act, the Personal Information and Data Protection Tribunal Act, and the Artificial Intelligence and Data Act, and to make consequential and related amendments to other acts. I would like to welcome our witnesses today. We have the Minister, François-Philippe Champagne, Minister of Innovation, Science and Industry, accompanied by, from the Department of Industry, Mark Shen, Senior Assistant Deputy Minister, Strategy and Innovation Policy Sector, and Samir Shepard, Director General, Marketplace Framework Policy Branch. I'd like to welcome you. We've been eagerly waiting for this study. And without further ado, Mr. Minister, I would like to turn the floor over to you. Thank you very much, Mr. Chair. It's always a great pleasure to be here before the committee. I have enormous respect for the colleagues and all the work you've done. I think you'll be pleasantly surprised because I have good news for the members of the committee.
And I'm here to even propose a number of amendments that you will see will allow us to move, I would say, very fast forward, I think, in that, because we have listened to you. And I would just say, as we start, AI, data, and privacy, for me, is kind of a whole. They are so interconnected that we're trying to lead the world in terms of what we're going to be doing. And you want me to stop?
Brendan,
yes,
Brendan, your
sorry.
mic is on.
MP, you want to be muted,
MP,
otherwise
Brendan,
you'll testify in my...
MP Henley, you're not on mute. Speaking of privacy.
Ken Hardy or Ken McDonald?
Mr. MP Henley. MP? Yeah, okay.
I'm just...
He doesn't have his headset. Okay, just 1 second, Mr. Minister.
It should be good now.
Okay, he's been muted by our friends over here. Bon, Mr. Minister, you can resume.
I see that Brendan is trying to Bigfoot me on that, but Brendan, good to see you, sir. Chers collègues, évidemment, j'ai l'honneur de présenter.
Colleagues, I have the honor to present Bill C-27 before your committee today. I'd like to point out the urgency and importance of this bill. Our legislation was updated for the most recently, more than 20 years ago. So this was well before Facebook, Twitter, and iPhone even existed. So just imagine the need to take action decisively and quickly. We can't, in my opinion, lose this opportunity to update the privacy laws of Canadians. Canadians are expecting tangible action from us, and we must meet their expectation. In addition, the technology is evolving very rapidly. You saw the last time we talked about ChatGPT. These are all new technologies that Canadians are seeing, and we're all dealing with the huge power of this artificial intelligence, which has risks and opportunities for us.
To these pressing challenges, it would build a stronger framework for privacy protection and introduce a new framework for the regulation of artificial intelligence, putting into practice the principles of Canada's Digital Charter. Le projet de loi C-27 mettra en œuvre des réformes cruciales.
Bill C-27 will implement important reforms to better align our bill on privacy with the best practices internationally, including the EU GDPR. We will strengthen the office of the Commissioner, the Privacy Commissioner, so that he has the authority to issue orders, oblige businesses to provide information and to be compliant, and to recommend certain sanctions that are even higher, the highest amongst the G7.
Intelligence technology. AI is advancing at a rapid pace and is quickly being adopted across Canada's economy. I'm happy to say tomorrow there's a huge summit that I'll be attending in Montreal, the All-In Summit with Yoshua Benjo and thousands of people coming from around the world to listen to Canada, but also to see what we can do together. Bill C-27 proposes robust guardrails for the responsible development, deployment, and use of AI systems. Part 3 of the bill, the AI and Data Act, is designed to protect Canadians from the risk associated with AI, to encourage trustworthy innovation, and to solidify Canada's place as a global leader in responsible AI. Canada is one of the first jurisdictions in the world to propose a legal framework for AI, and passing IDA will make Canada AI synonymous with safe AI around the world. I can tell you our Japanese colleagues, our European Union colleagues, and our American colleagues, we've all been in touch, and they see Canada as taking a leadership role in these regards. Tout d'abord, laissez-moi vous dire ce que la loi...
First of all, I would like to tell you what the AI and Data Act will not be doing. We will not be duplicating legislation in those areas where existing laws are already effective. For example, in areas such as the environmental protection or medical devices. Some AI systems may have real consequences for Canadian families, for consumers, systems which determine whether, for example, you get a loan or whether you're able to get a job that you would like to be hired for. So I think that what we're proposing will enable us to have responsible leadership, but also will be there to protect Canadians.
Things like ChatGPT, I don't need to tell you, you've all seen that in the recent months and even yesterday. A new innovation where we don't really know everything that they're capable of. And you don't need to take it from me, but I would advise you to read the letter that was signed by Yoshua Benjo and hundreds of people from around the world warning us that we need to take action. We know that they can do a lot of useful work for us, but they can also be used to spread fake images or videos on a scale that we have never seen before. Our laws are not currently set up to deal with these kinds of risks, but IDA will fill this gap. I know that all parties care about these issues, and I know this committee can play a vital role in protecting Canadians. So let's ensure that the technology is fair for all Canadians and that we have trust again. Bref, notre projet de loi repose sur des bases solides.
Our bill is based on a solid foundations. However, know that I have also listened to ways that we can improve ourselves. My office and my department have held more than 300 meetings with academics, companies, and civil society on this bill, and we've heard some very important contributions. I've also spoken directly with the Privacy Commissioner, and I listened to his recommendations, and I think that you will be pleased to hear that the modifications that we were proposing have, in fact, we have presented these recommendations to the Privacy Commissioner, and they're in line with what he is saying.
Foundation for privacy in Canada, including by increasing the funding of the Privacy Commissioner by nearly $20 million. We have also prepared a companion document for the AI and Data Act to shed more light on the responsible AI framework. Now, I want to put on the table specifically what our government will propose to improve the bill. So those are the amendments that we are proposing to the bill, and I would enjoy my colleagues to pay attention in particular to that section of what I will be saying. First, we will propose an amendment to recognize a fundamental right to privacy for Canadians. I think this is a big win for Canada. This is a major step forward, and I give credit to my colleagues and to this committee, you said that to me before, and the many stakeholders across the country for enabling us to move forward on this. Le projet de loi reconnaît déjà d'importants.
The bill recognizes new privacy rights, particularly the requirement that corporations use plain language in obtaining consent. Also, the data mobility rights and the right to request that your data be deleted. We want to ensure that Canadians are able to rest easy knowing that their privacy will be respected. I would encourage all of my colleagues to vote in favor of this amendment.
And I think Canada will be seen as a world leader in doing that. Deuxièmement, Monsieur le Président, vous m'avez peut-être...
Secondly, perhaps you've already heard us talk about children. We must take particular care of our children when it comes to the internet. And I think we have consensus throughout the country about that. I'm a stepfather to 2 young girls, and this is an issue that really touches me as it does other parents in the country. That's why our government is proposing that we add amendments to recognize and strengthen the protection of information concerning children. In my opinion, we must do more to protect children on the internet, and that's what we've heard.
While the bill significantly strengthens the Privacy Commissioner's ability to issue orders for compliances, as well as to recommend some of the highest penalties in the world, I understand it is important to enable them to pursue justice more quickly. That's why we will propose amendments to give the Commissioner more flexibility to reach compliance agreements with companies that are non-compliant with privacy law, allowing quick resolution of matters without implicating tribunal or the courts, and that's also something I've heard from colleagues around this table. Monsieur le Président, ensuite, je comprends que nous travaillerons ensemble sur la première.
I understand that we will be working on the first act on AI that's been put forward in our country. When I tabled this bill back in June 2022, we had intentionally designed a bill that was flexible, acknowledging that AI is developing extremely quickly. The basic requirement, contrary, is that we will have regulations that are future and innovative, and we will be there to protect Canadians. Our government intends to propose key amendments to add more structure, more specificity, and clarity in the part dealing with AI while preserving this flexibility. This BIPEDA, which is still in effect here in Canada, is going to be changed, and this is the model that we will be putting forward. The good news is that our bill was designed in a very flexible fashion, and so that we'll have new artificial intelligence categories.
Heard you. Let me remind you that our bill focuses on only high-impact AI systems. We will propose an amendment to define classes of systems that would typically be considered high impact. For example, AI systems to make important decisions about loans or employment. Second, we will introduce specific and distinct obligations for general purpose AI systems like ChatGPT. And I think it's very timely that we do that. These are systems that, for example, are available for public use and can interpret a wide variety of commands and generate text, picture, and audio. Third, I've heard that clearer differentiation of the AI value chain, that is, a person who develops AI system versus one who manages and deploys AI system in their business, is necessary to ensure that companies have a clear set of obligations. Fourth, we will strengthen and clarify the role of the proposed AI and Data Commissioner, including by enabling them to share information with and cooperate with other regulators, for example, the Privacy Commissioner or the Competition Commissioner. Next, and fifth, the fifth one that we're going to be proposing in terms of amendment, and I wish to align is to align it with the EU AI Act as well as other advanced economies of the OECD by making targeted amendments to key definitions and clarifying requirements. This change will specifically ensure that Canadian AI companies are interoperable with other jurisdictions and that our companies have access to international markets. That is fundamental in the world that we live in, to be able to be interoperable. So in conclusion, Mr. Chair, I hope these significant proposed amendments are as compelling for you as they are for me. We really put our best foot forward to get the support of the committee to really provide a piece of legislation that Canadians can be proud. Je suis optimiste quant au potentiel du Canada.
I'm optimistic as to Canada's potential in the global digital economy, and I'm very eager to cooperate with you, not only to implement a new Privacy Protection Act, but also an act that pertains to responsible artificial intelligence so that Canada will play a leadership role globally. We are going to see how we can do this in order to help our companies so that they can be responsible in this area. Thank you very much, Mr. Chair. Thank you, Mr. Minister, and thank you very much for respecting the time limits. That makes my job a lot easier. Without further ado, we'll begin the discussion with Mr. Perkins. You have 6 minutes.
And thank you, Minister. A couple of procedural questions at the beginning, if I could. One, I appreciate that you're going to table those amendments. Hopefully you will table them here at committee today so that the witness discussion that we have coming up in the next few meetings, that we can discuss those amendments and whether they achieve the necessary goals.
I'm not the master of procedure, Mr. Perkins, but I will defer to perhaps the chair of those who manage the procedure. I just don't know procedurally how this is going to be done, but certainly that's our intention. That's why I wanted to table, or at least explain them to you, so that they could be taken into consideration.
You can table a document with the any time. Secondly, given that it was almost 15 minutes for your presentation, I hope you'll allow us to spend an hour questioning you on this very important bill. And third, we have organized these committee meetings primarily for the next little while on the privacy parts 1 and 2 of the bill, and we will be coming back to the ADA part of the bill further on, and I would hope that you would be willing to come again to discuss the ADA part at the beginning of that study, as our next number of meetings are going to be really focused on privacy. So I hope you will entertain that invitation. I'd like to start off on the privacy side, since that'll be the focus of my questions today. Do you believe that the privacy of an individual and the data protection of that individual is primarily the paramount responsibility to the government to ensure that that has primacy over the needs of business to use that data?
Well, I think it's reflected in the fact that we're going to be qualifying privacy as a fundamental right for Canadians. I think this is a major step forward. And you'll see in the law that not only we do that, but we have also given power, the law would give power for people to at least have more control over their data. I think Canadians, are frustrated by the fact today that, for example, they can't transfer their data from one institution to the other. It's fair for people to have more power over their data, to transfer it, to manage it, and to be able to tell companies what they expect them to do with their data. For example, to have what we call very open consent. No bundled consent will be permitted. This needs to be in plain English, and I think this is really the type of things that Canadians expect from us. That
I appreciate that, Minister, but I don't think the bill does that. And I will draw your attention, first of all, it does require express consent, and it also requires express consent for new purposes. But 15.7 says implied consent is okay. And then 18.2 and 3 are issues, because 18.2 has a list of activities that are exempt from express consent. And most disturbingly, 18.3 says that the legitimate interests of a business in their decision-making process to use your data for things you did not give them permission to, even if it harms the individual, is okay. And it strikes me that the balance in this act, in particular because of 18.3, is in favor of business over the rights of the individual to protect their privacy.
Well, let me comment on the legitimate interest. I mean, the better example is that if you were to order something online and that the company needs to give your address, for example, to the delivery service, I think this was to deal with these kind of situations that I would think are kind of common sense, where Canadian expected if you're ordering something, you want it to be delivered, or you click to be delivered, and therefore there's your address. I would just point out to you on that, sir, that the Privacy Commissioner, if someone was to, let's say, overstep over the legitimate interest, I mean, if you look at the fines that are proposed under the law, that could go up to imprisonment. I mean, this is very serious business. So on one end, we appreciate that there could be a legitimate interest, but on the other end, we're going to be looking at that very carefully, and that's why we have increased the power of the Privacy Commissioner to act and to make orders so that this is proportionate, because the intent of the bill, and if you have some suggestions, but I can tell you the intent of the bill was to allow, obviously, for these circumstances where you have almost implied consent. You buy something online, you want it to be delivered. Obviously, the information will have to be transferred.
Well,
your address will have to be transferred.
I think that's a poor case, because when you sign up and agree for eBay or for any of these things, you already agreed to have the things delivered. So that is part of the check box when you sign up to the app and become part of it. But the issue is that you've provided a situation where essentially you have self-regulation, that the private sector self-regulates again, on its own initiative about what they think is a legitimate interest, and you've given them a legal defense to say, we believe this is in our legitimate interest to use data in this way, even though it harmed the individual. That last phrase, directly, basically from the bill, is very curious why the department and you as minister and government would think it would be okay to use data to harm the individual and give the legal authority of government to do that, or of the private company to do that.
Well, I would say it's equally surprising from a conservative member that you would not allow business to have legitimate interest to share that information for valid business purposes. I mean, you have to understand that under the bill, you have the privacy commissioner with very significant fines, up to imprisonment.
So why does an individual have to apply to the privacy commissioner to protect my privacy? Is that what you're saying?
Mr. Perkins will let the minister respond.
I'm just trying to answer. I disagree with you. I think the legitimate interest is necessary in cases. I gave you an example, which is very clear. And I'm saying that we have a lot of framework around that if anyone was to abuse that or to take measures that would go against the intent of the bill, they're subject to criminal penalties. I mean, this is very serious business. The fundamental right that we say we recognize is the privacy of Canadians. This is a very limited exception. This is very limited in its scope, and it's going to be supervised by the privacy commissioner. And I'd be happy to hear from you, sir, if you have any other ways you suggest that we address that. The intention is to protect the consumers, but at the same time to allow legitimate business to happen, because there's a number of examples. People were giving us in testimony, if you buy a watch and you want to measure your pulse, you're not going to consent every time that they measure. So there's a number of things that we just need to allow for business to function and also for small and medium-sized business to be able to operate. But at the same time, I can assure you that my resolve and the resolve of this team is that there's significant guardrails around that and that we will make sure that we protect the interest of Canadians.
Merci, Monsieur le Ministre. Je passerai maintenant la parole à Madame Lapointe.
Thank you, Mr. Minister. Madame Lapointe. Welcome, Minister Champagne. The PIPEDA saw the day 20 years ago, and now you mentioned that Facebook didn't exist at that time. I think you've struck a balance between in this bill. The bill has to give Canadians the assurance that their data is safe and that their privacy is respected. But at the same time, it encourages innovation that is good for the economy. Given the importance of this bill, I think it's very important that we hold consultations. In your speech, Minister Champagne, you said you listened to the stakeholders and that your department heard from 300 people and organizations about their concerns. Could you talk to us a bit about the conversations that took place and what led you to put forward the amendments that you have put forward? Thank you for your comments. I think this is a bill that shows to what extent Canadians and parliamentarians have listened to each other. There were over 300 consultations that took place. These people contributed to the process, and that's reflected in the number of amendments that we've made. And the people...
Oui, Monsieur Massé.
Thank you. Sorry, Mr. Minister, but I just, because I haven't seen amendments. So we have some ideas that have been presented, which I'm really encouraged by. But if there are actual drafted legal amendments, I'd like to have them in front of me if they're also being used by the minister right now and by my colleagues. I don't have those amendments. Amendments are legal context that go to the legislation, or are we at ideas right now? I just want to get that clarification because it's really important, because if we do have amendments, I'd like them to be tabled in front of us. That's all.
Thank you, Mr. Massé. It's my understanding that usually these amendments are tabled at clause by clause, but however, if it's the intention of the minister, as I highlighted, that he's open to amendments and he intends to present amendments to the bill, then I will yield the floor to the minister to answer that question. Yeah.
The point of Mr. Massé, those are going to be tabled at clause by clause. That's the way I'm told this is normally done. What I'm telling you is where the direction, because this is my opportunity to be in front of you to say what we intend to do. And obviously, the legal text of it will be tabled in accordance with due procedure. But I wanted, for the benefit, because for me to appear here without telling you what we have in mind in terms of what we're going to be doing would have been counterproductive because, for example, privacy as a fundamental right. I mean, we could be discussing that for half an hour, but we agree. So therefore, that's already something. But there will be an opportunity, obviously, for the committee at clause by clause to reflect on the exact text of it. But I wanted for the benefit, and I hope colleagues appreciate that. I took a step further just to say, to have a meaningful discussion, let's highlight what we intend to do, and in clause by clause, obviously, colleagues will have the opportunity to look at the legal text of it that reflects what I just said today.
Thank you, Minister. We'll go back to Madame Lapointe.
Oui, alors.
Yes. We can do two things at the same time. The consultations. So, yes, we held a series of consultations. We know, as you said, well, for the members of this committee, for the people who are listening to us in their homes, we haven't updated the Privacy Act in 20 years. Just imagine. I'm not sure that Google even existed at that time. So we're talking about metaverse, and yet our act predates Google. So imagine how things have evolved in time. Who controls our data? How can we transfer this data? How can we protect it? How can we protect our children in this environment? I feel the urgency here. I hope my colleagues are feeling the same sense of urgency as well. We have to take action. We have to take action. Do we want to just keep an act that is completely out of date? No. We saw what happened during the pandemic to children. There are so many young people who were online, and we've seen the negative effects that this has had on some of them. As parents, you have the right to request at one of these platforms to remove or delete data pertaining to children. It's so important. We listen to a lot of people, and I'm proud of what we're doing today. As a parliamentarian, I can say that young people, parents, the world is looking at us. We need to evolve with the times and keep up to date and protect Canadians.
Minister, in your opening statements again, you talked about another area that you were looking to alter, and that's to strengthen the Privacy Commissioner's ability to penalize companies that aren't compliant with Canadian privacy laws. So can you tell us more about this proposed amendment and how you plan to incentivize companies to comply?
Yeah, well, that is we heard from people that they wanted the Privacy Commissioner to have more feet. I think that's the expression in English, with more power and more abilities to make orders and to come with penalties. Because, for companies that do not comply, and Mr. Perkin was mentioning possibilities of companies not complying, you want to have a regulator out there that will be taking strong action, because we want, on one end, to have something on the books, but one thing is all about enforcement, to make sure that we have, and we have a Privacy Commissioner that we'll have now, and to have talked to him, I can tell you, he's pretty happy that we are modernizing the law. But not only we did that, but we gave them means to do that, because amending the law without, new funding would have been, I think, disingenuous to help protect Canadians. So our role as parliamentarian is to amend the law to give him more tools, more powers. For example, we talk about these consent agreements, so you don't need to go to the full court system, but if there's violation, he'll be able to issue orders, he'll be issued to issue penalties, and I think at the end of the day, that's going to be more efficient. But that was something, you may recall, the Privacy Commissioner, when we started with the first version, had a number of amendments that he wanted to see. I think we have reflected all his amendments. Last time I spoke to him, he was in support of this bill because he understood that we meant to give him all the powers needed for him to do his job. And I think if I'm the Privacy Commissioner, what I want now, the funding, but I also want a new law that will give me the powers to do that, because imagine our Privacy Commissioner today operates under a law that existed before Google, so obviously he doesn't have the tools needed. This was something asked, and I think members of the committee, if I recall, we're also calling for the privacy commissioner to have substance, to have powers, and that's what we've done in terms of having more powers to do the job that Canadians expect him to do, or her.
Merci beaucoup. Monsieur Lemire, la parole est à vous.
Mr. Lemire, you have the floor. Thank you, Mr. Chair. Thank you, Minister. We finally got to this point with a bill. I believe this all started back in January of 2022. You tabled this in June, but we are at this point where we can deal with it today. My question is very short, but we need clear commitment, precise commitment. Will Quebec be exempted from the sections on privacy? I believe that you're aware of the Bill 34, which was adopted by the National Assembly. You said that there will be no duplication. Will Quebec be exempted? The bill will be complementary, but with respect to the sections that you mentioned, I think I'd like to turn to one of my officials because you want a specific answer to a specific question. So I'll ask Mr. Shang to give us an answer to that question. Thank you, Chabra. Thank you for your question. Now, the province of Quebec, with respect to the proposal of something that is substantially similar, that should continue with this new act, the CPPA. And now there are some differences between the privacy sections between this bill and that of the province of Quebec. So the Quebec law will override the new federal law, so you recognize that? Listen, what I understand and what we want is that this act should be complementary and not a duplication. Mr. Lemire, as we always do, we try to obtain the same objections with the same we have the same aspirations with respect to both laws. We obviously will have this attitude towards the Quebec Act because Quebec is ahead of us in terms of its privacy laws. That's why we have to coordinate things. And if I may, it's important to have a federal framework because one thing I heard from the various stakeholders that if we don't have an overriding federal law, we may have a Canadian system with very piecemeal series of legislations. It's very difficult when you're dealing with various jurisdictions. It becomes very complicated. So we have to have an act that is uniform to a certain extent when it comes to privacy protection. But I respect what the provinces have done. But you do recognize Bill 34. This is an aspect that is very important. It's the reason why this law should be adopted very quickly. So we have to ensure that our businesses don't get two different messages. That's your responsibility, in my opinion. With respect to AI, we'll take the time to analyze your amendments, but there is something that is very important to me is, do you feel that this bill is a first step? Or do you think that it could be updated shortly thereafter because there are standards that are being adopted by various countries and you also have to take into account the particularity of Quebec culture? But you mentioned the interoperability. This is important and fundamental. Will this be aligned with the European legislation that is Mr. Lemire, you said with a great deal of elegance exactly what I was trying to say. That is, we talked to our European colleagues about interoperability, and you're quite right. Our European colleagues are looking at what's going on here in Canada because I think that the European framework will not come into play until 2026, if I'm not mistaken, in Canada. We'll be the first country in the world to have a legislative regime like this, and it's based on principles. So it's an evolving system, if you like, and it'll enable us to. We're going to be based on principles because you're right. The danger of having a very specific law is that technology gets ahead of it. So we're going to have regulations. I think that the best example we can is ChatGPT. As soon as when we saw each other the last time, well, the things have changed since we last spoke. Does the bill talk about provide for a provision for automatic revision so that we sit down and see where we are internationally? To answer your question, the bill gives us a framework that will evolve. So I don't think there's. In certain pieces of legislation, we talk about a review every 5 years, but this is not a prescriptive act. This is why we give ourselves a framework. That's why we provided this document. And when we talked about high impact AI, we specified things very clearly, but we're hoping that this act will survive in the years that lie ahead so that we'll have a good framework. And that's what the Americans and the Europeans are looking at. We were at the G7, and you know that France created the AI partnership. And so we're looking at everyone's looking at what's happening in Canada, France, Europe. We're trying to we're going to see where the regulations go in the world. Thank you. Thank you very much.
Massey, the floor is yours.
Thank you. First to our analysts, how many witnesses do we have scheduled, or to Mr. Chair for right now?
Well, as we discussed at the steering committee, we have about 13 meetings, so if you make the count, about 4 or 5 witnesses per meeting.
Yeah, so we have 13 meetings. And so I guess this is what I want to clarify, and I don't want to spend more of the time. The point of order is that, so you can actually at the last minute table specific amendments. But aside from that right now, and I like a lot of what you said here, and there's a ton of things I'd like to know, but we don't have a copy of your speech. And so is the intent then of the government to have all those meetings and all those witnesses come and testify to us about the legislation that you have tabled that is real, and then the concept that they have to respond is just to your testimony here today? We've asked all those groups to actually present us with the amendments before they sit down at this table. So my concern is that we are now, if we don't have these specific amendments that are legal, then we then have to go on speculative assumption of what you said in the last several minutes, then to weed out all their concerns. So I think we have a huge firestorm that's going to be created here, because I know my phone's going to be ringing off the hook, is that how do they actually give a response to what you promise are ideas, but we don't have the actual amendments? What if we had those amendments right now, those groups and organizations that give us good testimony? And just for the record, even on C-34, we had to have several timeouts because we had to deal with amendments that even nobody quite understood the consequences of. So is that the plan? Or, like, I really appreciate what you've come here. There's some significant things that you've said, and I couldn't even write them down. I don't know if you talk as quick as I do. So Pat Martin used to say to me, there's no periods in my Hansards. So what I'm really worried about right here is how do we go forward and when are we going to get these specific amendments? Because we have to have our legal teams go through them, Library of Parliament, our analysts, and everyone else like that. And how do we do that if we don't have anything more than ideas? Yeah.
Mr. Chair, first of all, Mr. Moss, I'll try to speak slower so that no. Also for the interpreters, you remind me. I want to thank them because I tend to speak fast, and it's. I'm not the only one, I guess, around here. But 2 things. So the first thing you were asking, Ken. Listen, for the committee's perspective, I hope you appreciate this was meant to be helpful, because we thought that if I come here and we talk about, for example, recognizing privacy as a fundamental right for half an hour and we're already going to do it, it doesn't really make sense. So my thing was to be helpful. Happy to put my speech, my remarks on the record. And I was consulting at the same time with the officials how quickly we can draft these amendments, because in my testimony, hopefully, you get a sense of where we're going. And I will do as much as we can with the officials, maybe even to provide you, as much information, even if it's not the full legal text of it, respecting the procedure, and the chair would allow for that. I am happy to give the speech, but I think the full amendment, the intention was that they come when you do clause by clause. And people who come to testify, they should listen to me, because obviously if they're going to testify on things we're already fixing, that would be helpful.
Yeah, not everybody's going to believe. So here's what I went through with my bill. Actually, the Minister of Environment actually created some amendments, and it went to the Liberals, and the Liberals, your own team, with the chair, ruled the government's own amendments out of order. So that happens here. So I guess the thing is this, is that, I mean, I can take what you maybe put it in a chat GPT and actually have it do the amendments for me. But, until we see, and that's why I just impress upon you and your team, is to get them, because if they don't fit the legislation, or if there's a challenge with them technically, and I'd like to ask you questions about some of those things, but I want to go through this because I think it's more important for us to do legislation, then we're going to be spinning in circles here.
Appreciate it. Yeah. I like your creativity, Mr. Massey, about how we could go about amendments. Hopefully, we won't get there. But what I can commit, Chair, like I said, this was meant to be helpful. I hear the concerns and the comments from colleagues. We will do our utmost to provide an outline of what I say, and I'm happy to share that. First, Sorry. No, I was saying, first, my remarks, which, I'm happy to put on the record. And secondly, to provide the chair, maybe in a letter, more specificity, so you have that in a letter. And then I would certainly work with our members to be able to provide the detailed wording of the amendments so that they can be provided to you as quickly as possible. Like I said, my intervention today, take it in a positive way, that I just wanted to progress the work of the committee and say, this is what we intend to do. So therefore, if we're in agreement on that, we can focus on the things where they need to be improved, because those are already things we intend to do.
I don't disagree, and then many of them are positive, but we have to deal with the reality is that the people that are going to be sitting in where you're sitting there, they're not going to just trust speculation on potential amendments. And even if they were done with the most genuine interest, they could run into technical legal problems that we may not foresee. I don't know how much time do I have left, Mr. Chair?
About 15 seconds.
Okay, well, I do see these as positive things, but they have to be real, and they're not real to me until they pass the medal of being passed by and analyzed by even our analysts that actually legally are there, and then going through the due diligence. So thank you for the intent here, because it is helpful, but until we see it in front of me, then that's the challenge we face. Thank you, Mr. Speaker. Mr. Chair.
Thank you, Mr. Massey. I'll now yield the floor to Mr. Williams.
Thank you, Mr. Chair, and thank you, Minister, for being here. And thank you for at least starting with the amendments. I guess I have a bunch of questions, so while you're here, we're gonna start asking you. And we'll start with privacy as a fundamental right. I spoke about this in the House. Until now, I didn't think the government took it seriously. So it's nice to hear that you're making that statement. And to make the point very clear, as I spoke in the House, nowhere in the current document does it state that privacy is a fundamental right. So I'll ask you, Minister, first of all, where in the document is that going to be stated?
First of all, that proves that I listen to you when you speak in the House. You should be
several
be
times
happy.
this week we've had that proven to us.
You should be happy that it reflects that we've been listening, not only from you, but I would say a number of stakeholders. I want to give credits to people. I've talked about the privacy right. Like I said, I talk about the concept today that we're going to insert it. If you ask me in which specific provision,
so I'll ask you specifically, Minister, do you support an amendment that would put that in the purpose statement of the document?
There will already be in the body of the law that when we're going to be presenting the amendment, that will recognize that properly. You remember when we started, there was issue about jurisdiction, and we put it in a preamble to indicate our intention. But now we're going to state that as a fact, and I had discussion with the Privacy Commissioner on that, and I think it's something that was wanted not only by you, but I think the Privacy Commissioner and I think a number of stakeholders in Canada.
And I'm sure you understand, the witnesses will come out, and we've already talked to you, and we'll have the Privacy Commissioner on Thursday, so we'll certainly be asking for that. I was asking if you support. I'm happy to hear you have it, and certainly, as been mentioned by my colleague, we'll have a lot of different witnesses come out, so I just wanted to hear where you thought it would be. Certainly, it's nice to hear that you think it's going to be in certain other places. I'm going to follow with my colleague as well, talking about legitimate interests. So certainly right now, We've heard it's too broad. We've talked about it's far too broad. We certainly want to look perhaps more in line with the GDPR, which really defines legitimate interests in their Article 6.1f as one of the lawful bases for processing personal data. And according to the GDPR, legitimate interest means that a data controller, the entity processing the data, can process personal data without the explicit consent of the data subject, the individual to whom the data pertains. Or in other words, they really define it a little more clearly. They even have what's called a legitimate interest assessment, so an LIA. We've talked about the privacy impact assessment in our version, but we haven't really looked at an LIA. Would you support amendments that look to define legitimate interest more clearly, but more in line with the GDPR?
And I'd like to say, even just as a principle, and I'll come to your specific question, a lot of what we've done, and I have a full list of the things that we've been doing in order to align with the GDPR in the European Union. And certainly, if you were to come with an amendment that would allow us to, clarify something that I tried to explain, that we tried to put in the law that would align with the EU, certainly that's something, Mr. Williams, that would consider, because a lot of the things we've done on definitions are aligning with the EU. We talk with the EU all the time on these things. We want to be aligned because they're very keen about what Canada is doing as well, because we're going to be first out of the gate, I think, with your help. Certainly, so if you come with something that you think we can better circumscribe that definition or avoid unintended consequences, listen, you see how much I've been listening to you. Look at all the amendments we're proposing to make it a better bill. So definitely we'll be listening.
And we appreciate that. I think the intent of all the witnesses coming up will be getting that balance, and we understand that balance needs to be there. Certainly, you've talked about $20 million more for the Privacy Commissioner, and we're going to be debating a tribunal and the use of the tribunal. There are different speeds of the tribunal which have worked and haven't worked for the Competition Bureau, so we're certainly looking at that, what's going to work for this instance. But one thing that came out last week out of the Rogers Shaw Tribunal was the tribunal itself actually had to pay $13 million to Rogers. So certainly from that, we're learning that perhaps the process needs to be improved even on the competition side, not just the privacy side. So as the minister right now making amendments or recommendations, you talked about giving $20 million. Well, in this case, if that was the privacy tribunal, they already lost it. What changes would you make as a minister, or would you recommend amendments to this tribunal process, to the Privacy Commissioner itself, to ensure we don't have that happen at all when it comes to this process if we were to enact a tribunal?
Just to be very specific, obviously that was base funding. The $20 million is base funding for the Privacy Commissioner for him to operate. Part of the thing that I heard from him was that, Minister, if you modernize the law but we don't have the funding to have the tools to enforce, it's not going to work to the extent that I think every member of Parliament expects. So I must tell you, with respect to the competition law matter that you're saying, as you know, this is usually not coming from base funding from the organization or the competition tribunal in this case. I thought long and hard about a tribunal. I'm a lawyer, and I was wondering, court of general jurisdiction, specialized tribunal. I'm not inclined to create new structure. That's probably part of my DNA in terms of trying to think, could we have court of general jurisdiction? But I was convinced by experts that, having people who understand, more deeply this matter as opposed to courts of general jurisdiction would be better. And in addition, just to go to the fact that we have consent agreements, we expect that most of the things will be done to consent agreements, whereby the Privacy Commissioner can get to kind of almost a plea bargain agreement with the offenders, so they don't have to go to the tribunal. This was something that we don't want to clog the courts. Understand that, a specialized tribunal, I agree with you. Most of the experts would say in this particular case, like in ADA as well, you need some skills to understand that, and it was better, and it should improve justice and be faster and less expensive. But I think the real answer is to the consent agreements, because I think most offenders, I don't have statistics, but most offenders would come to a consent agreement with the Privacy Commissioner.
Merci. Thank you, Minister. We'll now turn to MP de Brussen.
Here at committee today, and Minister, thank you for being here. I know that in the past we've talked about the fact that my community has a very large arts industry. I have a film studio district in over the past summer, I was talking with a lot of actors in my community, members of ACTRA, writers who are members of Writers Guild. They've been really watching what's been happening in the United States with the strikes in the United States, and in particular, the issue that has come up in those strikes, one of the issues has been about AI and the impact of AI on the arts industry, particularly use of actors' voices or images, use of written materials by writers who work for film and television. And one of the questions that they were asking of me was what we can do in Canada to make sure that we are creating the right protections for artists like actors and writers in the context of AI. They actually were very excited to see that we have this bill. They recognized that we are ahead of many countries in having this kind of legislation. But the question that they wanted to know is what can we do specifically on the types of issues that I just raised?
Thank you very much, Mr. Bruce. And first of all, you're lucky to have a film industry. I think many of us around here would like to have one as well, to have, because they bring a lot of economic benefits, and certainly it's a great industry. You're quite right that our friends down south are looking very much at what's going on in Canada. I can tell you, not only down south, but the other side of the pond in Europe, because everyone understands that, AI is... No one country can have all the answers, but I think in terms of cooperation and making sure to the OECD or G7, we take initiative like the Hiroshima initiative we took with Japan, who had the presidency of the G7. I think people understand, even the Leaders Summit, people talk about AI. It's that important today. It's at the G7 Leaders Summit, they talk about AI. So it just say how much this is on top of mind, not only of creators and actors. And I'd like to tell you more specifically on that, but I have an announcement coming, and one thing that they have advised me is not to say everything necessarily today, but there's an announcement coming with respect to that, which will address... which will too late, yeah. Which will address some of that, because you're quite right. We need to put a bit of focus on that and understand the impact that AI can have, and also generative AI. I saw something yesterday. I don't know if colleagues saw that. Was it in the New York Times or even now with image and voice, that people can, it's going at a speed. That's why I'm saying I hope colleagues feel the same level of urgency I feel, because every day we kind of learn of a new aspect of that technology that goes beyond what we have already seen. So having a framework, I think, will be much needed, and it will allow for responsible AI, because we talk a lot about the challenge and the risk, but let's talk about a lot of responsible AI. Tomorrow I'm going to be with, people like Cohere in Canada, which is doing great work, Xanadu. I mean, there's tons of company, I can think, Coveo, which are doing a lot of responsible AI in this country. So you want to push innovation, because Canada is at the forefront of AI. I think if you look around the world, remember my first meeting in Washington, I remember they said, Minister, one place where Canada is way ahead is on AI. So we have this, we're at the cutting edge of it. But I think to continue that, we need to have a framework, and that's what we're proposing.
Well, I only have about a minute left. So I'm just going to ask you to make sure that we're including the thoughts and interests of artists, and particularly artists, actors, and writers in the film and television industry, but I'd say our creative industries as a whole, as we go forward, because they're deeply concerned, and we want to make sure that we have a thriving industry here in Canada. Just the other last piece, and I know I don't have much time, though, is you kind of hit the nail on the head. Things are moving really quickly. How do we make sure that this legislation remains evergreen and doesn't get stuck as a one snapshot of time?
Well, that's a very good question, both on the artists, I would agree, and that by providing a framework, I think, the way Canada's been doing, if you think about PEPIDA, the existing law that deals with privacy, it is quite something that we have achieved to still be relevant 20 years after it was passed, at a time where things have evolved. Like I said, you didn't have Twitter, you didn't have Facebook during that time. The same philosophy has been applied here, because either you can be very prescriptive, and some jurisdictions have decided to do that, but the risk, like you said, is you become obsolete like the month, I don't want to say the month after, but maybe 5 years from the time. Our approach has been like we did with PEPIDA, to say, better to have a framework with guidelines and broad principles, and then to regulation and codes, you can evolve with the technology, because I don't know, like you, what may be coming 6 months down the road or 5 years down the road. But one thing I know is that you only have a chance once every decade probably to update these things. So they need to be relevant for the long term. That's kind of the philosophical approach that Canada has been taking. That's why our partners around the world are so interested in what we're doing.
Merci, Madame de Brussen. Merci, Monsieur le Ministre. Monsieur Lemire, la parole est à vous.
Mr. Lemire, the floor is yours. Thank you, Mr. Chair. Thank you, Minister. With respect to the AI, it's based on self-regulation. How are the businesses going to come up with codes of conduct to ensure the government has to approve these elements without necessarily having some teeth? That's the real concern. How are we going to verify the audit? You say it's going to be done by audit. What about transparency, copyright, transparency? This is essential. That leads me to an essential question. If ever there's some abuse, there are consequences, perhaps in the privacy individual who has the privacy breached. Is it the seller or is it the user who's going to be brought to on charges? That's important that we get this resolved. Because otherwise, if we don't have more specificity, that'll create a lot of confusion. Mr. Lemire, I really like your question. You've touched on a good subject. But why? That's why we have to really talk about these two distinct groups. Somebody who develops a system, someone who uses a system within a business. These are two completely different things. There are different obligations as well, obviously. There's a lot more obligations on the developer because he will have to ensure that he's dealing with a high-impact system. So, as I said in my opening statement, it's not your choice of music that interests me. What people are listening to us is they're concerned. Well, I'll give you an example. Is this a robot or is this an algorithm that's going to be making a decision whether or not you are given an insurance policy? Or I think we have to ensure that the algorithm isn't biased and steers you in the wrong decision. And you have to be aware of this. Just imagine, let's say you buy an insurance policy and you don't even know if it's an individual or a robot. This has to be clarified. The methodology used has to be explained, and there has to be a sign. When it's a robot that's talking to you or acting on behalf of a business, you have to know, because what concerns people today, and that's where we have to take action. Let's say you're applying for a loan. Mr. Lemire, I think you're entitled to know whether it's a machine or a person who's made the decision. And what about Canadians have to know all of this. Light has to be shed on this, because that's why we want to, in this bill, deal with that. And I think that there's opportunity in the law, but things can go off rails too. Innovation, responsible innovation. Sure, Canada has to do that, but at the same time, we have to protect our citizens as well. Inaudible for the interpreter. I'm very eager to look at your amendments, and I must say that this whole exercise, I do agree with my colleague Brian, because the exercise is more difficult without having the amendments before us. If I may, Mr. Chair, my purpose was to advance the debate. If we have an intent but we don't talk about our intentions, well, that's one thing. We need to have the draft amendments. We can provide you with the text, the legal text, as quickly as possible, so that you can study them especially when you get to the clause by clause. Very appreciated. Thank you. Mr. Massey, the floor is yours.
Mr. Chair, the one good thing is that we are good at robotic repetition and knowing that here, especially at 2 o'clock to 3 o'clock in Ottawa. with question periods. So we should be able to fix that problem, I'm hoping. So the tribunal kneecapped the Competition Bureau this past couple weeks ago. Now, does this tribunal in the bill as written right now have the same capability to do the same thing to the Privacy Commissioner?
First of all, let me comment on that, and then I'll turn to the officials for the very specific thing. I was like you, pretty surprised, I would say, to see that decision. And obviously, and I think as we're looking at competition reform in this country, we have to think about some of the things that we may do that would address that. But with respect to the Privacy Commissioner, I'm happy to defer to officials specifically on your questions.
Yeah.
Quick follow-ups.
Yeah, so just very quickly, the tribunal has two functions. One is, upon the recommendation of the Privacy Commissioner, to actually issue an administrative monetary penalty in relation to the violation of the Consumer Privacy Protection Act. And the second is to ensure that there's an appeal mechanism for any decisions of the Privacy Commissioner, and it's on the basis of law that that determination would be made such that there would be a review or an appeal of the decision. That's also reviewable.
So it's the cost allocation is the issue. So I guess I only have a brief time here. Is that if I want to know, you can take this away. I want to know whether they can do the same thing in terms of the financial penalty on this tribunal process. And if second to that, if we have a fix in this bill for that, are you agreeable to do the same thing for Bill C-56 right now to protect the Competition Bureau, to make them consistent so we don't have the Competition Bureau having to pay a financial penalty in the courts versus the Privacy Commissioner?
It's a very good point, Mr. Massé, and as I told you, when I saw that, I was already thinking about how, in terms of competition reform, wants one to look at that. And your point is well taken, that whatever provision we should have in one tribunal should be reflected in the other. And I think looking at international best practice is what I'm doing now to see what's being done in other jurisdictions. The reason why the tribunal is you didn't want to be the judge and executioner at the same time. So we needed to provide like an appeal level, because in the case of the Privacy Commissioner, you could have monetary penalties. So you need to have, in terms of due process, having a way either to Court of General Jurisdiction or a tribunal. But your point about what we've seen recently is something that's on my mind that we're looking at.
Yeah, well, I hope there's openness to even if make sure that doesn't happen here, because I will have no business with this tribunal process if that's the case, if they can do that. And second of all, if we do have a fix, then I'd like to see if we can do it in Bill C-56 to have consistency, because it's an affront to the offices, and it detracts from the whole point. And
let me just say to the point of the member, just briefly, Chair, I want to be clear with every member and Canadians we're watching. C-56 is dealing with a number of things on competition which are focused on grocery, but that I want people to be clear, this is not the end of the road. We're still looking at competition and bringing reforms on competition, whether it's going to be included in 66 or the other. I think it's probably part of the general thing we're looking on competition. C-56 was really to deal with things that matter to Canadian immediately, which is around affordability and grocery.
Agreed, but if there's consent, we can open up a chapter of any bill. So I'm hoping there's openness.
Even if we have unanimous consent, we could approve it tonight.
Yeah, there we go. I'm in.
Merci beaucoup. Monsieur le ministre, si vous le permettez, il nous resterait deux...
If I may, Minister, there are two members who will be given 5 minutes each for the second round. That would bring us up to 5:40. Is that okay? So, yes, Mr. General, you have 5 minutes. Thank you, Mr. Chair. Minister, I have a great deal of respect for you, but I find it hard to believe that the government, knowing that it's been 20 years since the PIPEDA was updated, and then we find out today that your government is making amendments to a bill that was created for this situation, that is privacy and artificial intelligence. Today, you talk about these amendments that will define what the bill will be. But we don't have the amendments. So how do you want us that, well, normally we should be meeting with the Privacy Commissioner on Thursday. We should be asking him questions, but we don't have the amendments. So that just doesn't make sense. That's the first thing that I wanted you to talk about. And these public consultations, to my knowledge, You heard from the variety of 300 different consultations. There are thousands, 40 million Canadians will be impacted by by AI and these new technologies. I think that these consultations dealt with privacy primarily, but they weren't consulted on other matters. So you hold public consultations. Do you think that we need to have a broader consultation? That's my first question. On your point with respect to the amendments, Mr. General, I have a lot of respect for you. But on the one hand, you can't blame us for listening to you. We did this so we could come up with something concrete. The worst thing would be to be here in committee and to come up with things at the very last minute. That's why we have listened to you. The amendments will be in line with what we've heard from you. It's good to have a minister that listens to you. As far as the consultations, Mr. General, I talk to a lot of people in the AI sector. A lot of people want to be heard on this matter. The fact that we've already got a good relationship with AI companies in the company, we know them. We have a national strategy. We've consulted with experts. Asho Benjo is one of the fathers of AI. We heard from him. I think that means that we are starting to hear from people. We have heard from people who know this. We're talking to people who are the leaders in the area of AI. I agree with that. But in my question, I said, here we are, September 2023. This bill was tabled in June 2023, and we find out today that there will be substantial amendments. We're not talking about little minor amendments here. We've just been told that these are all things that are absolutely essential so that we understand the bill. What I'm saying is that when you've decided to do these amendments, well, we should have already got these amendments. How do you want us to work with our witnesses and ask questions? We could have asked the questions of the government. How is he going to be able to answer us without having the amendments? That just doesn't work like that. I really have a difficult time understanding this process. Well, we find ourselves 1 year later talking about a bill without seeing the amendments. We're told that we're going to be hearing from witnesses on Thursday in 2 years' time. Well, that just doesn't work. If I may, Mr. General, I've heard you, but these are amendments that you wanted. We're headed in the right direction. But it's not just from you. We're talking about the stakeholders who have suggested we can't go faster than that. So, Mr. Minister, have you drafted these amendments? Do you have them on your desk somewhere? They've already been drafted because that's fundamental. If they're drafted, please table them. What are you waiting for? Why not table them now? I have another question. You talked about your 2 daughters or the children of your spouse. You talked about children. In Canada, you know very well that there are 13 different jurisdictions. And how are you going to be able to balance all of this so that the act is adapted to young people, because this is fundamental. You explained it in your opening statement. Protecting youth is important. But with age differences that vary according to the jurisdictions, how on earth, how are you going to do this? Can I answer, Mr. Chair? I thought that the protection of children was fundamental. I'd like to give children's rights. what's upsetting to me and for you as well, because I know you're a good person, is to think that you wouldn't have the right to intervene and ask that a platform that's using information about your children not deleted. There's a problem. We're going to give rights to people that can avail themselves of these rights to protect their children. I think just for that alone, we have to do that. We need to protect the children. We have so many examples of what's happening with kids online. We'd have strengthened this provision in order to protect young people.
Thank you, Chair, and good evening, Minister. Great to have you here at committee. Minister, in your comments, I found something very interesting that you stated. You said, I believe it's with regards to the context was with regards to the AI portion. You said that this is not a prescriptive act, but rather a framework. And I really wanted to see if you could elaborate on that, on your thoughts there, and why it's important with regards to a framework as we move forward rather than a prescriptive act.
Well, thank you for that question, Mr. Sabara. As always, a pleasure to hear from you and your question. I think, particularly when it comes to artificial intelligence, we see at the speed of change that the only way forward is certainly to have a framework as opposed to very prescriptive. I mean, you may see other jurisdictions have decided to go in a different direction, but how can you ensure that you will be relevant 6 months from now, 1 year from now? I mean, ChatGPT, I think, highlighted that to the world that in a matter of months we found ourselves with generative AI, things that probably most of us did not necessarily believe were possible that are now commonly used by students, by people around the world. And now I've seen yesterday that there's new addition on voice, on image. So my point is that having a framework is what allows us to be relevant. We probably don't know necessarily where the technology is going to go, but I would say we need to put guardrails. And the best example, when I was with the Chief Science Officer of Canada, and colleagues should reflect on that, when people were saying AI will be what it wants to be, she said the best analogy is when people were talking about cloning. And when we decided as humanity that you won't clone another human, it's not that cloning became whatever cloning could be, because potentially you could do that. But we said as the international community and as people, we will not allow that to happen. So AI, we have precedent in the history of mankind to say technologies that could bring us in the wrong place, we can put a stop on that. And cloning was the best example where humanity decided we won't go there. And AI is the same thing, that it's not just something that should float and go wherever it may go. We need to have a place where we say this is what we as the people, those are going to be the boundaries under which you can have creative innovation, responsible innovation, helping people in so many ways. But there's going to be a line where, you should not cross, because that would be detrimental to people.
Thank you, Minister, for that. And I think the framework or a principles-based approach is definitely the way to go, and thank you for that explanation. With regards to children, you had mentioned that you're the stepfather of two children. Myself and my wife are raising 3 daughters. We know how much time they spend online, on YouTube and Roblox and so forth, and chatting with their friends, and that protecting children's data, and I would say children's right, is something fundamental that we all as MPs, all 338 of us, are seized with and are very concerned with, because, like you said, 20 years ago, technology between then and today, and even 2 years ago, technology has changed and evolved. So I wanted to ask you about how important that this bill is to ensure children's data is protected as technology continues to evolve and, of course, become more sophisticated.
The fundamental principle behind this act is to give more power to the people with respect to their data. Generally. And when it comes to children, it's even going a step beyond, because the example was given. If you have a teenager which opened an account at some stage in her life, and you become an adult at a certain point of your life, and you want to delete or have this account removed, I think it's just fundamental, in my view, that you should be able to do that you don't have to fight, the different platforms for doing that, but you should have a right to do so. I mean, maybe at my age, I didn't have like a digital, time in my life when I was a kid because it came after. But the kids of today, they have a digital life starting some very early. And for me, it's shocking, honestly. I sit here as a Canadian, as a stepdad to two girls, as just someone, and say, really, if I wanted to force, let's say, Facebook to delete something when she was a teenager or a friend did something, you don't have the right. There's something shocking in my mind on that, and that's why I'm so passionate about this bill that we need to act to better protect our children. And even if you're an adult, to move your data, you talk about innovation, having the bank being able to move your data, it's your data. What we're saying is that's your data. The right to move it and to manage it is yours. And it's not like the company. So having more power over your data to be deleted, to be moved, I think it's going to spur innovation. Imagine if you could ask a company, just move my data to this other provider because this is what I want. It's my data. I think it's a step forward.
Merci.
Merci.
Thank you very much, Minister. This is all the time we had. Thanks for joining us today to answer the members' questions. Colleagues, we have a hard stop at 6. I will very briefly suspend for the Minister to leave, and then we have a few items of committee business, and then if we have time, then some questions for the officials until 6. So meeting suspended. Thanks again, Minister. resume, and I don't know if we'll get much time for questions to the officials, because first I would like to have consent to adopt the subcommittee on agenda and procedure of the standing committee, the fifth report approved. You've all received a copy of the steering committee's report. Are there any comments, or do I have unanimous consent to approve the steering committee's report? I'm looking at you, Mr. Perkins, as well. We have consent. Perfect. It is so approved. And if there are no other items of business, I see Mr. Lemire. Monsieur Lemire.
Donc, Monsieur le Président, vous me permettez de
If I may, I'd like to go back to the motion that I tabled on September 19th, and it was adopted by our committee. It reads as follows, and I'll stop when you feel that it's no longer appropriate for me to continue. Perhaps, I hope I don't have to read the whole thing in its entirety, but that pursuant to standing order, the committee undertake a study on the modernization of the regulatory framework and the convergence of wired and wireless products to ensure that future decisions are informed by robust data and recommendations for the benefit of all consumers in terms of accessibility and affordability, that examine this convergence with relevant stakeholders and what they can enable through, technological advances such as 5G, fiber optics, Wi-Fi 6, and many others, that examine the need for ubiquitous connectivity, necessary data transmission speeds, and innovative opportunities for businesses and consumers in Canada and internationally, that it scrutinize the operating costs of these technologies and the maintenance of so-called critical infrastructure, that it examine the need for network, and this is an aspect that's very important, and it comes from the government, that the need for network resiliency in the face of climate change, that it specifically investigate unused spectrum in more remote and rural areas, as well as deployment targets, that examine the need to expand mobile connectivity to improve public safety. That's another government-inspired issue, particularly along roads and highways, that examine telecommunications tower construction programs and infrastructure deployment financing. And finally, that the government allocates a minimum of 6 meetings for conducting the study, and that it report its findings and recommendations to the House. Thank you, Mr. Chair. That's the motion. You presented it a week ago, and there was an agreement that you would work with other parliamentaries. I believe you did that. Is it the will of the committee to approve this motion? Conscious of the fact that we may not get to it before some time, given the amount of work involved.
By Mr. Lemire. Thank you. Colleagues, and now we have only 10 more minutes with officials, so it will depend on the committee's will. You might be re-invited, though I'm sure that comes as no surprise to you, Mr. Shan. But we'll use the time we have left, 10 minutes. So I would suggest I'll split the time 3 minute, 1.5. Mr. Viss.
Just a friendly motion that hearing from witnesses today is extremely important in the context of Bill C-27. So I'd just like to move and hopefully get unanimous consent that we invite the officials back as soon as possible at your discretion, Chair, to provide us the time we need to begin examining this bill.
Is it the will of the committee to adopt this motion? I'll work it out with the clerk and officials. Yes, Mr. Lemire.
Je pense que dans ce cas-là, ça serait d'autant plus.
I think that would be very important that we see the amendments so that we can ask questions pertinent to the amendments. But that doesn't change. The motion presented by Mr. Viss is to re-invite the officials as quickly as possible. I don't think that they can't. It's not in their purview to deal with the election. I did understand that they were commit to come back as quickly as possible. At least there's a clear intent, but I can't make a commitment on the minister's behalf. But Mr. Viss, with respect to the officials,
our colleagues at the earliest convenience, yes. Adopted. So, Mr. Viss, you still have a bit of time for your questions.
Yeah, I'm going to turn my time over to Mr. Williams.
Mr. Williams.
Thank you, Mr. Chair. My questions are really concerning the added costs that'll be to business from privacy regulations, specifically to the cell phone industry. Have we looked generally at what the GDPR has, what the effects of that legislation have been to small businesses, but specifically to cell phone companies in Europe?
Merci, Monsieur le Président, pour la question.
Thank you for your question.
Studies on the impacts of the GDPR as a regulatory tool on overall industry. I'm not aware of a specific one to the telecommunications industry, but I am aware of studies that have shown the disproportionate burden that has been faced by small and medium-sized enterprises, which was something that was very top of mind for us as we were contemplating the CPPR to ensure that we were very mindful of the impacts it can have on small business.
Thank you, Mr. And thank you very much for that answer. And Mr. Chair, I'm actually on this topic at hand, and I know this committee, we're going to be studying privacy, and we're going to be looking at AI, and we're going to spend a lot of meetings on that. But I am, and we are very concerned about the costs of cell phones in general. I'm going to move a motion, Mr. Chair, that this committee report to the House its disappointment with the government's failure to reduce cell phone bills by 25% as promised in 2019, while continuing to approve mergers of cell phone providers. Further, the committee reported its concern about how some of the highest cell phone prices in the world are contributing to the cost of living crisis in general.
Okay, so Mr. Williams just moved the motion. Has it been, I understand, Madam Clerk, that it's been sent around to all MPs? Are there comments on the motion before? And would you mind, Mr. Williams, just repeating the motion?
Not at all, sir. That this committee report to the House its disappointment with the government's failure to reduce cell phone bills by 25% as promised in 2019, while continuing to approve mergers of cell phone providers. Further, the committee reported its concern about how some of the highest cell phone prices in the world are contributing to the cost of living crisis in general.
Yes, Mr. de Brussen.
Thank you. It might just be because I am a substitution today, but I don't believe I received the wording. I just wanted to check, was this something that was circulated as wording previously, just so that I understand? Is it something that just arrived now? So it's just because the chair referred to how we might have the wording. I don't. It was just emailed. It might not have been emailed to me.
Mr. Williams, considering that, and thank you, MP de Brussen, considering that this is not on topic and that no notice was given, I understand that this to be noticed and that it'll come for debate.
Well, as noted, it is on the topic when it comes to privacy and how those added costs are going to add to the cell phone. So very much on topic with the matter at hand.
Let me just take 1 second to review the wording, the exact wording of your motion, because I haven't had notice of that. So. I failed to see, Mr. Williams, that it is on topic, but you'll have opportunities to bring it forward with proper notice in due course. So
Chair, can I just raise a point of order?
Yes, of course, Mr.
Yeah, Chair, as a guest here at the committee as well, the rule is that matter at hand deals with, is it on the matter being dealt with at the committee? The member was asking questions to officials specifically on cell phone prices, and then he moved a motion on cell phone prices. That very clearly was the matter at hand because it was the matter that followed the line of questioning. So that is within the rules, and so I think it's pretty clearly in order.
Mr. Sorbara.
Chair, is it reasonable to ask if we move to adjourn debate?
Yes, you can sure do that, Mr. Sorbara. So it was moved to adjourn debate.
Yes.
Adjourn debate, but
I understand what once it's moved, it's not debatable. So there was a motion to adjourn debate by MP Sorbara. So Madame la Greffière will take a vote.
Madame Lapointe. Oui. Mr. Hardy.
Yes.
Mr. Sorbara.
Oui.
Mr. Van Buyden.
Yes.
Mr. Généreux.
Wait. No. Sorry, no.
Mr. Perkins.
No.
Mr. Viss,
No.
Mr. Williams,
No.
Monsieur Lemire,
En conformité avec l'opposition qu'on a à tous les baillons, évidemment, on va s'opposer, donc je vote non.
Mr. Massey,
I'm being consistent with the chair's decision and adjourn debate, yes.
So that brings us back to.
no, it brings us back to questioning the witnesses on the bill.
On the bill. Yeah.
So this brings us back to questioning the witnesses on the bill, but considering it's 5:58, we will actually adjourn this committee and definitely re-invite you officials. Thank you for your presence here at committee today. Thank you to all members, and this meeting is adjourned.